All rise.
Kosovo Specialist Chambers is now in session.
Be seated. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-07, the Specialist Prosecutor versus Hisni Gucati and Gucati&Haradinaj.
I note that Mr. Whiteman is not here today. Any change with the defense?
No, Your Honor, thank you.
No, Your Honor.
Thank you. I note that Mr. Gucati and Mr. Haradinaj are both in the courtroom. Today, the defense will continue its cross-examination of Ms. Pumper. As I said yesterday, we will be sitting in the first two sessions today until 1 o'clock, and we will adjourn for the week, continuing Ms. Pumper's testimony if necessary on Monday. In the afternoon at 2:30, the panel will hold an ex parte session with the prosecution on ongoing Rule 1023 matters. Now, before we bring back the witness, the panel will address some preliminary matters. First, in relation to the tendering of exhibits. As you all remember, the panel deferred a number of exhibits tendered through Ms. Pumper until the end of her testimony. When that discussion comes up, the prosecution is expected to read out a concise summary of the witnesses' declarations in the open court in open session. This is in line with paragraph 93 of the Order on the Conduct of Proceedings. I note that the prosecution provided these summaries in F-367 Annex 1. At the same time, the prosecution is also expected to indicate for each tendered exhibit its proposed classification. The defense will be asked to give an indication of its position on the proposed classification. If an exhibit is proposed to be confidential, the SPO should also indicate if a public redacted version can be made available, and if so, by when. For the future, whenever a party wishes to tender an exhibit, it will also indicate its proposed classification. Parties are invited to discuss the matter of classification before the issue is brought before the panel, with a view to find an agreeable position if possible. This concludes the oral order on the tendering of exhibits. I again remind both parties that when they use a document in court with a witness, they should identify its exhibit number if it has one, or an MFI number if one was given to it. And if there's a question about that, you can quickly consult with the court officer for the number. This is important to ensure the clarity of the record. Now, Mr. Cadman, you indicated yesterday that you expect to call another expert witness. Can you please tell the panel what the topic of the expert opinion of this witness refers to, and how long you would need to prepare and file his or her final expert report?
Your Honor, I would expect to be able to file a relatively brief expert report. It's on investigative standards and chain of custody matters. We have identified an expert, Dr. William Wiley, who is an experienced investigator who would be willing to provide a statement or a report. I will be able to confirm by the end of today and can report back the timeline, but I have impressed upon him that the proceedings are ongoing and we would have limited time in which to file that report. The application will be made today for leave to file that report, and I'm in Your Honour's hands as to the timeline, but I have impressed upon Dr. Wiley that we will be given limited time to prepare a report.
And you will have a definite time yet today?
I will.
We'll rule on that Monday then. Or possibly even today if you get it on file early enough. Madam Court Usher, please bring the witness in. Good morning, Ms. Pumper. You may be seated. We are going to continue with your testimony today, Ms. Pumper. Mr. Reese, you may continue.
Thank you, Your Honour. Just wait for the witness to settle.
Thank you.
I'm settled.
Okay. We finished yesterday, Ms. Pumper, just by looking at the registration check that was done on that vehicle index number for the Volkswagen Passat that was provided by Mr. Gucati to an SPO officer on the 17th of September, relating to the delivery of documents to the KLA War Veterans Association headquarters the day before. And we've seen that check, the request had taken place either on the 25th or the 26th of November, with the check coming back the next day, the 27th of November. And we saw the name of the person that was to which the index number was registered. Do you remember that name?
I don't.
Can we put 089049 back up on the screen? It's a redacted document. I don't think there is any further classification on it. There's a redaction in relation to an address, but the name of the person has never been redacted. I don't regard it as a name that requires us to go into private session. But then again, the trial panels have taken a different view on a number of occasions to me about this. I'm in the trial panel's hands as to whether we do or not.
Is there some reason you need his name? We're all aware of what occurred. I'm sorry. We're all aware of what occurred. We're aware of the license number. We're aware of the fact that the notification was made. It doesn't seem necessary, and there's a privacy issue.
I can certainly continue without referring to the name.
Do that, please.
Although I had understood the presumption being that these are public proceedings, so that the presumption was not to demonstrate the necessity of referring to something in public, but rather the necessity of not referring to something in public. But I am, as I am always, in the trial panel's hands over this.
All right, then. Do not use the name.
Right.
All right.
So you can see the name there, please, Ms.
I
Butler?
can,
Yeah,
yes.
okay. And that person was belatedly invited to be spoken to by the SPO, and that occurred on the 18th of December. We'll come on to that in a moment. Are you aware that on the 18th of December there was another colleague of yours who spotted that person, when he arrived to be spoken to by the SPO at the interview location? Firstly, the vehicle that he was driving was the vehicle with that index number.
I have to apologize. Can you repeat this again?
So are you aware that when that individual attended the interview location on the 18th of December, he was seen by a colleague of yours, at least I assume it's a colleague because the name is redacted, so it might even be you, was seen by an SPO officer to arrive in a vehicle that had the registration plate that Mr. Gucati had provided,
I'm unaware of this.
in a car that matched the description that Mr. Gucati provided.
I'm unaware of this.
And the SPO officer noted that he had an identifiable gait, that's this individual, that matched the gait seen by the journalist who recorded the man delivering documents to the KLAWVA on the 16th of September. Are you aware of that as well?
Your Honor, if possible, there is an objection because the witness has already answered that he is unaware of these circumstances.
You can answer if you're aware of anything. You can answer that question.
I'm unaware.
So, are you aware that that person was then interviewed on the 18th of December then?
Was what?
Was interviewed on the 18th of December?
I'm aware to that effect that I recall that my colleague has mentioned that in passing.
Right. Can I ask which colleague?
Request that the names of SPO staff members are not repeated in open court.
So can we go into private session?
Just for that one question.
Yes.
Any objection?
An objection in terms of relevance of who is the SPO colleague who
Oh, it could be relevant. We will go into private session.
Microphone for the owner, please.
We're back in open session, Your Honor.
Thank you. We are in open session. Mr. Rees?
And that colleague of yours didn't mention that the individual who attended for interview on that date was driving a car that matched the description given with the number plate and had an identifiable gate that matched the person seen on the video footage recorded by the journalist delivering documents.
No, he did not.
Can we look, please, at the interview, which is 088 395 TR ET, Part 1, red.
Is there a P number for that document?
There's not. Can I say, Your Honour, I've done my best to look at the documents that I intend to refer the witness to today and compare them with the ongoing list that's being developed for P numbers and PMFI numbers.
Okay.
I think there's one that I identified.
Okay. Go ahead. Thank you.
I have already spoken to Madam Court Officer before the court came to session, and I've explained that if I've missed something, she will point out to me. But
that's a
I
good
will
practice.
try and do it myself where I've identified it.
Good practice. Thank you.
Your Honor, Specialist Counsel confirm for the record, is ERN 088395 or
935?
935.
935-TR-ET Part 1 red. We can see the first page of the interview. The interview was conducted by Prosecutor of an Associate Prosecutor of the SPO's office. I take it I won't name the individual, but you can see the individual there, Ms. Pumper, we can all see the name.
I can, yes.
And also an investigator. Again, I won't name the name, we can see it there, and an interpreter. And the individual had counsel to assist, but if you look, please, at page 3, line 17, after some prolonged introductions, we can see it's made clear that he was interviewed in the capacity of a witness. as an experienced investigator, 20 years, can you assist as to why he was interviewed in the capacity of a witness as opposed to a suspect?
Objection, Your Honor. The counsel is asking for the legal opinion of the witness. She's not here to provide legal opinions to the court.
Sustained.
From what you know now, would you have regarded him as a potential suspect in your
Objection
experience?
again is the same kind of question with different words.
Sustained.
Did you play any role in the coordination of this investigation, Ms. Pumper?
I did not, with the exception of the search at the Warwater Association and the review of the badges.
Yeah, who did? Who was responsible for the coordination of the investigation?
I was told by the Deputy Specialist Prosecutor that it was him and the Specialist Prosecutor.
Right. Are we going to be able to ask the person who was responsible for coordinating this investigation any questions during the course of this trial?
Is that a question for the court
It's
or
a
for the
question to
witness
Ms.
or?
Pumper.
Or
It's a
Yeah.
question of Ms. Pumper. She may not be able to answer. But
Do you
it's
know
a
that,
question to
ma'am?
Ms. Pumper.
You can answer.
There is
cannot
objection,
answer
Your
that.
Honor. on
I
this.
understand.
Yes.
Answer the question.
I cannot answer this question. I cannot answer this question.
And as an experienced investigator, you would agree, would you not, that criminal litigation is not a game to be played, is it?
It's argumentative and it's not a question for the witness.
It is argumentative, sustained.
We can see that after some further introductory questions about father's occupation and brothers and sisters, we eventually get to the meat of the interview, page 6, line 18. Question. You told me that the license plate is, repeat, I'm not going to say it again,
Thank you.
correct. Yes, answer. Are you the owner of that
Your
vehicle?
Honor,
Yes.
objection again. I think the classification of this document is confidential, and in addition, the witness, I think, made clear that she had not involvement with this particular interview, so it's not established what the basis for the questions on
Where-
this interview to this witness.
Why are you asking this witness about this interview that she did not attend?
She is an experienced investigator of 20 years. She has played a part in this investigation, albeit she says limited, and we have no other means of dealing with this material because the SPO are not calling the people who have been said to be responsible for the coordination of the investigation. So I intend to go through this. If it requires us to go to private session, then I ask for that to be done. It is a short passage, as we will see, which is very much the point of the questioning.
I'll allow you to question her briefly about this. Please avoid any identifying information by name, address, or license plate number. And if you need to go beyond that, we will go into private session.
I don't think,
And let's limit it to what she actually knows and not opinions about the procedure, because she wasn't there, she had no effect on it.
thank you, Your Honour. So we, at the part of the transcript where he had just confirmed he was the owner of the vehicle, how long have you owned it for? Since mid-February this year, so that's 2020. Has that vehicle always had that license plate, or has it changed at any time? It changed when I purchased it. Going over the page.
Can we have the page changed?
So since February, it's been the same one that we just mentioned, right? Yes. And are you the only driver of this vehicle? Or do other people use it? Answer, I am the 90% of the time. I'm the person who drives it. Very rarely my wife uses it too, and my father. There is then a short passage in which they talk about whether working from home or in the office, and he confirms back in the office from June. And then at line 23 of page 7, the prosecutor puts, so we have information that a vehicle with the license plate, and then it's referred to, was seen in the vicinity of the KLA War Veterans Association on the date that I just mentioned, the 16th of September 2020. Over the page, please.
The interpreters kindly ask the speaker to read slowly. It's impossible to interpret at this speed. Thank you very much.
Slower.
No. Have you ever been to the offices of the War Veterans Association? No. So just to locate you better, the Associate Prosecutor says, then gives the address of the KLA War Veterans Association in Pristina and asks, does that address sound familiar to you? No. Have you heard anything, perhaps in the news, concerning documents which were delivered to the KLA War Veterans Association and then made public by the same association? I heard on the news, but I do not know anything in this regard.
Slower reading, please.
Question. So you don't have any information about who provided those documents or who may have been involved in this incident by any chance? Answer, no. Over the page, please, line 3. Do you by any chance remember whether you had lent your car to anyone on that day, the 16th of September 2020, or around that day? Because I know it's very specific. No, I did not lend it to anyone. Do you know anyone who works for or is associated with the KLA War Veterans Association? No. Do you know or have you ever spoken to Gucati&Haradinaj, for example? No. Husni Gucati? No. Faton Klanako? No. Mex Inshallah? No. We have no further questions for you today. Following that briefest of interviews, were you asked to undertake any further investigations into, for example, the credibility of that individual?
I have not seen this interview and I have not been asked to do any investigation into this matter.
So no investigations, for example, that might corroborate that brief account?
Objection. The question has already been asked and answered.
Asked and answered. Next question.
I specifically asked about credibility issues.
You ask her. Were you asked to undertake any further investigations into, for example, the credibility of that individual? And she said, yeah. She said no. And what's this question?
I wanted to ask whether...
I'm reading it, just a minute. So you said, so no investigations, for example, that might corroborate. That has to do with credibility. No, she's answered the question.
Do you know if anyone else was asked to undertake any further investigations into the credibility of that witness?
I have no idea.
Do you know who would have an idea and could tell us whether anyone was asked to undertake any further investigations into the credibility of that witness?
I would refer again to the Specialist Prosecutor and to the Deputy Specialist Prosecutor.
Well, you can refer it to the Specialist Prosecutor, but unfortunately we can't. Can I offer that exhibit to be admitted?
Any objection?
Yes, an objection considering that it would fall under Rule 153 to 155 of the rules, and there is no indication that any of the requirements of the relevant rules are met.
I'll defer ruling on that. It needs to have an MFI number.
Thank you, Your Honor.
Or,
Your Honors, that will be 1D1 MFI.
thank you.
And furthermore, if I may add, there is no relevance to the charges in this indictment.
Well, understood. Go ahead, Mr. Rees.
I intend to move on rather than argue that point now. I understand that's the position the trial panel wishes me to
The
take.
court will take all of that into consideration and rule on it. I understand the issue.
Yes.
Okay.
Is there an SPO officer who has been designated as the officer responsible for disclosure to the accused in this matter of material that may assist them?
I have no knowledge.
You said yesterday that you weren't particularly au fait with the rules of procedure. Is that right?
Can you rephrase, please?
That you hadn't read the rules of procedure in any great detail, you said.
What I believe I've said, I apologize if that didn't come across, that I have not read whether the chief prosecutor, whether it was legal for him to announce the indictment.
Are you aware that there are obligations on the prosecution to provide to an accused any information the specialist prosecutor has in his or her custody, control or knowledge which may reasonably suggest the innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence?
Objection, Your Honor. He's asking for a legal opinion of the witness about the applicable rules on disclosure. This is not a relevant question for this witness.
This witness has already indicated she isn't acquainted with the rules of procedure in detail, and that is a legal opinion that she's not qualified to give at this point, and I'll sustain the objection.
Your Honour, I asked whether she was aware about the obligations.
And she said, all right, are you aware of the rules of procedure in general?
I have an overall idea, yes.
Thank you. So I asked her specifically about Rule 103, if I may, and her
Are you,
knowledge of
are
that.
you specifically acquainted with Rule 103?
I am not.
All right.
Well, let's leave the label. Listen carefully to the words. So I'm just going to read the rule, okay? And all I want-
Mr. Rees, this is an improper question for her. She's unaware of it, and she's not going to be put on that spot, so move on. I'm sustaining the prosecution's objection.
So, Ms. Pumper, who is aware in the SPO and is responsible for bringing to the specialist prosecutor's attention material that may reasonably suggest the innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence?
I would refer you to the deputy specialist prosecutor and to the specialist prosecutor.
Yes, but Ms. Pumper, as talented and hard-working as the specialist prosecutor and the deputy specialist prosecutor no doubt are, they are not responsible, are they, for investigating matters in the first instance?
Your Honor, there is an objection. The question has been asked and answered several times.
Your Honour, at this point, can I ask for the witness to withdraw, because I'd like to address the trial panel about these matters and explain further the relevance and the line of questioning. not private session. I'd like the witness to withdraw because I'd like to address argument about this matter.
Microphone, please.
Madam Usher, would you please escort the witness out of the room temporarily? All right, Mr. Rees.
Your Honour was very kind enough to clarify at the end of the witness's first day of testimony that Miss Pumper was here to testify concerning the normal operating procedures in her office, of which she is aware. I am seeking to explore with her the normal operating procedures in her office, of which she is aware. If I can just expand upon that, because I understand that there is an element of laying the groundwork in any submission. It must be, one would have thought, a normal operating procedure of the SPO that they are alive to their obligations under Rule 103 to make disclosure of material which may reasonably suggest the innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence.
Slow down, please.
And to make disclosure under Rule 102(3) of material which is deemed by the defence to be material to its preparation. And as we've already clarified, of course, that requires a proactive approach from the specialist prosecutor in the first place to consider that question for the purpose of preparing a Rule 102(3) notice and so on. Now, that does not mean, of course, it would be rather trite and facile of anybody to suggest that that means under Rule 103 and Rule 102 that the specialist prosecutor himself is required to review every single piece of paper that officers working underneath him produce in the course of their investigations. One would have thought it was normal operating procedure for there to be a process in place by which other members of the SPO staff, closer to the investigations themselves, are designated to review the material that is being obtained in the possession of the SPO office and bring to the attention of the specialist prosecutor or other persons designated or delegated to which delegation has been made, material which may meet Rule 103 and Rule 102(3). That would be a normal operating procedure, rather than anticipate the specialist prosecutor, or indeed the deputy specialist prosecutor, to trawl through every piece of paper that his office produces. I wish to ask her about the normal operating procedure that she is aware of. And if she is not aware of any such normal operating procedure, I wish to ask her how, in her experience, these matters do work. Because if she then says, I am not aware of any such procedure, that also is a matter that the trial panel ought to be aware of when considering both disclosure issues that are ongoing and will continue to ongo, because, of course, the obligation on the specialist prosecutor to make disclosure is an ongoing one throughout the course of the trial and indeed after. And it's also relevant in particular to the issue and the plea of police incitement that we are pressing. Those are my submissions. That's why I wish to ask this witness about those matters.
Your Honor, I would like to have a chance to reply if possible.
Thank you, Mr. Rees. Thank you, Mr. Rees. Judge Mitro has asked permission to ask a question of you.
Thank you, Judge Miss, and we will come to the prosecution in a second. As you probably and properly read it out, Mr. Rees, the order was that she would be giving evidence about the normal operating procedures in her office, of which she is aware. Now, you are asking her questions, in effect, about the disclosure process within the office. Shouldn't you perhaps start with a question as to her knowledge, if any, about that matter? She hasn't given evidence to this point that would suggest that she has any role or particular knowledge of that process. Now, if that question is asked and she gives you an indication that she has no involvement and no knowledge of that process, that should put an end to that line of questioning, shouldn't it?
Your Honour, she began her evidence by saying that she is an investigations coordinator. She is responsible for coordinating investigations. She might have then gone on to limit her role in this case, but her position is involved in the coordination of investigations. And I'm not asking about some esoteric area of the rules. I am talking about a process which is at the very heart of any investigation and prosecution, which is the fair approach to disclosure of material that is required to be disclosed to the defence. That is something that, and Judge Mitro, I can see the red light going on, but if I could just finish the point. That is something where, if the witness says she is not aware of it, that doesn't mean that I have to accept it. I'm entitled to probe that, because I may well address the trial panel in due course as to whether the trial panel thought it was credible that Miss Pumper, a coordinations investigator of some 5 years' experience with the SPO since it began, responsible for conducting a search in this case, which I will come on to deal with, who had worked for the SITF before that, and many years' experience before that for both ULEX and other European modern police forces, a denial by her that she's completely unaware of any approach to disclosure, a systematic approach to disclosure. I may well address the trial panel. That is wholly incredible in due course.
Well, the red light has come on, Mr. Rees. First thing, you seem to assume that as an investigating coordinator, she would have a role in the disclosure process. Now, you haven't established that. If you want to ask her that question, ask her that question. It's an assumption that is not, for the time being, on the record. The second thing is, if you want to be in a position to make the submission that you have indicated at the end of your submission, that what she says is not credible, you will have to put that proposition to her in fairness so that she can address it. But again, it's a suggestion you may wish to consider if you want to continue asking questions about issues of disclosure, that you establish whether she has any role in relation to this matter, and if so, what that role is. If the answer is otherwise, you may consider, and again, this is a suggestion, moving on to another topic.
And of course, Your Honour, firstly, of course, if I wish to make that submission, that her evidence lacks credibility, I must put that to her. And I must, before I put that submission to her, explore matters with her as a matter of fairness, because the line cross-examination does not work by me simply standing up and saying to the witness, I find your evidence incredible. I have to explore the groundwork first. And that means being allowed to have a proper opportunity to question the witness, even if her answers are, no, I'm not aware. That doesn't mean that I then have to accept it and move on, in my respectful submission.
Thank you, Mr. Rees. Prosecutor, you may respond.
Yeah, just a few points, Your Honor. The first one is that the defense is stating its case through questions put to his witness. Well, the defense will have every opportunity to state its case in the course of this trial. It's not clear what is the purpose of doing so by questions to a witness who specifically stated that has no knowledge about the matters the counsel is talking about. And secondly, the disclosure in this case has been litigated by the party at length. Had the counsel wished to raise any other matters in relation to the disclosure process, it should have done so in due course and not through questions put to a witness. Third, the witness not only stated that didn't have any role in the disclosure process, but said that she's not aware of the meaning of the rules on disclosure, in particular Rule 103. So any further line of questioning in this respect would be already superfluous.
Judge Gaynor.
Ms. Bellici, just in respect of your submission that you've just made, where you referred to the case of the cross-examining party. Now, under Rule 143.3, where the witness is able to give evidence relevant to the case of the cross-examining party, he or she may be examined on the subject matter of that case, provided that the cross-examining party puts to that witness the nature of that case. So what exactly is the problem with the cross-examining party putting the nature of its case to the witness?
The nature of the case that the defense wants to advance has not been put to the witness yet. So this is the first point.
So your request is that the cross-examining party should put the case squarely to the witness?
This would be the first step, but also, like I argue, in terms of relevance of whatever question the counsel is putting to the witness, and competence of the witness to answer this question, above all, when she stated already that she's not competent to speak about these matters.
Thank you. Thank you for those clarifications.
All right, Mr. Rees, the witness has given answers that would lead me to believe that she does not know anything about Rule 103, but I will go along with Judge Mitro's advice to you that you first ask her the question whether she does, what her role, whether she had any role in 103 or 102 disclosures. Unfortunately for you, if she says she did not, that will probably be the end of that line of questioning. So we will call the witness back into the...
Before the witness does return, I do understand the trial panel's position, of course, but can I ask that I can develop the point in this regard also? If she says she's not involved in it, am I allowed to develop how material, for example, that she comes across in her role as an investigator, which may meet that definition, is passed up the chain and brought to the attention of the prosecutor so that it is disclosed? Because if it is the case, Your Honour, that there isn't such a process, that also is relevant to both the trial panel's decision on disclosure matters, but also the plea of police incitement.
I believe she testified in quite a bit detail about exactly how evidence that comes into her possession goes into the system and goes up the line. But getting to the point of running the case is not her job.
No, but we're not dealing with the submission of material that the SPO wish to rely on. I want to ask her about material that she might come across. That is material that is to be disclosed because it undermines the SPO's case.
Well, I guess we disagree about what she testified to, because she talked about her not deciding what was and was not relevant. She put the evidence she found into the system and tracked very, very accurately what happens to that.
She also said in evidence, when I cross-examined her, that not all materials that they come across are submitted into the Xylab system. She did say that, Your Honour. So perhaps I can clarify that matter at least.
Let's start out to just ask the question that was suggested to you, and we will rule on anything further beyond that. We'll please call Madam Usher, please bring the witness back in. I won't make a ruling, Madam Prosecutor, on your objection at this time, but it's noted, and I will rule on it shortly, if necessary. Be seated, Ms. Pumper. Ms. Pumper, the defense attorney, Mr. Reese, is going to ask you a very specific question about your knowledge or of your process, your participation in issues of disclosure, and you can answer that question. He can ask it, and you can answer it.
Thank you.
Are you involved as a investigation coordinator in the process of bringing to the prosecutor's attention material which might help the accused in any investigation or prosecution?
That has nothing to do with my position. I would do that anyway.
Is there a specific role then in an investigation for a person who is responsible for making sure that material which might help an accused in any investigation or prosecution is brought to the attention of the prosecutor?
I'm not aware.
In your previous experience working for ULEX, were you aware of the designation of a disclosure officer in cases as a normal operating procedure?
I was not.
So that we understand, it is not part of the normal operating procedure of the specialist prosecutor's office to designate an individual as a disclosure officer responsible for bringing material which may help the accused to the attention of the prosecutor.
I'm not aware of that. I can't confirm or deny.
Well, you haven't come across it as part of the normal operating procedure of the SPO.
No.
Does it simply fall then to each individual SPO member of staff to bring to the attention of a prosecutor any material they might come across which may help the accused in any investigation or prosecution?
Your Honor, can I clarify something, please?
Yes, you may.
I'm aware that there is an exculpatory review ongoing in the cases. So if that is what the defense means, yes, we have exculpatory review going on.
So in each case there is a review ongoing, yes?
Well, I'm not involved in all of them, but I know that we have exculpatory review as part of every case.
So we are, of course, just dealing at the moment with normal operating procedures, okay?
I don't know what you mean under normal operating procedures. I apologize.
But does the SPO not have... I mean, each investigation is not commenced on an ad hoc basis, is it? Or is it? Do you have some guidance to the conduct of investigations?
I'm not sure what you mean.
Well, is there any internal guidance as to how you conduct an investigation?
We're all experienced investigators and
Yeah.
we work with prosecutors. I'm unaware of something in written on a guidance how to conduct investigations.
And you're each trusted to get on with the job how you see fit?
Objection, Your Honor. It's not clear what this line of questioning is about. It's not about this case. It's about the general undertakings of the office. Is not relevant to the specificity of this case and to the competence of this witness.
Overruled. It's foundational. You can continue.
So I asked you if there was any internal guidance as to how the SPO and its officers should conduct an investigation, and you said you're unaware of anything written as to how to conduct investigations. And then I asked, so you're each trusted to simply get on with the job how you see fit? And then Ms. Bellici objected. That's been overruled. So can you answer that? Are you each trusted simply to get on with the job how you see fit?
Give me a moment to think of my answer to that.
Please, take your time, please.
So when you have this large amount of material and this broad mandate, so how it is that is ultimately the specialist prosecutor, deputy specialist prosecutor who make a decision which case to pursue and how to pursue it. So, but clearly we are the ones who are confronted with the material in due course of our research. So if I come across something which I consider relevant or that I consider should be brought to the attention of the prosecutor, I will do that in either verbally or maybe I make a proposal, a work plan. So I don't open cases myself or decide whether to open or not to open them, if that helps.
It does help. Of course, you said that in our specific case, your role was relatively limited, yes?
It was what it was.
And you clearly weren't aware, this is not a criticism, but you were not aware of all the issues in the case, were you?
No, I was not.
So, from your point of view, being unaware of all the issues in the case, do you accept that there may be material that you have seen, the relevance of which would not be apparent to you because you haven't seen, you're not aware of all the issues in the case? Would you concede that?
No, because I can confirm I haven't seen any material which the prosecutor, Ms. Bellici, hasn't seen.
Right. But you can't confirm that for one of your colleagues, can you?
Of course not.
No. So, the use of one officer who is tasked with making himself aware of the overall issues in the case and then ensuring that other investigators collate, retain, and list relevant material so that it all can be brought to the attention of a prosecutor to review it for disclosure, that is a role that you are not familiar with within the Specialist Prosecution Office. Is that right?
My answer is, in this case, I was told that the coordinators were the specialist prosecutor and his deputy. I am unaware whether they have appointed anyone, whether there was such a role. All what I can say is I had very limited involvement, or very limited, let's not judge it. I was involved in coordinating the search and preparing for these declarations and the testimony today.
Yes, I follow that, but I was asking you about the general position. You are not familiar with the use of an officer tasked with making himself aware of the overall issues in the case and then ensuring that other investigators collate, retain and list relevant material so that it can all be brought to the attention of a prosecutor to review for disclosure.
Your Honor, the question has been asked and answered.
Sustained. You asked the same question twice.
Well, she answered it not in the general but in the specific with this case, but I take it that one can infer, therefore, she's not. Can we look, please, at Declaration ERN 084015?
For the record, that's P86 MFI.
Before I do that, in fact, move on the declaration, can I be frank? Are you really saying that as an experienced investigator of 20 years, you are unaware of the role of a disclosure officer?
Asked and answered, Your Honor. Objection.
Well, that was a direct challenge to credibility that I thought I was required to make.
I'm sorry, overruled, you may answer that question. And also, could we use the MFI number for that document, please? I believe there's one, right?
Yes, there is.
Yeah.
Yes, Your Honor, that is P86 MFI.
So are you making mistakes? My mistake is...
Microphone for the council, please.
Opposed to the declaration, so I haven't done the task of looking at the declaration and comparing to the exhibit list, so I'm going to have to ask Madam Court Officer to assist me on that point. Back to the question. Shall I repeat it?
I think that would be best.
Yeah. So, Ms. Bumper, are you really saying that as an experienced investigator of some 20 years, you are unaware of the role of a disclosure officer?
That is correct.
Thank you. Can we look then at tendered exhibit P86 MFI, which is begins ERN 084015? And we are, as we began yesterday, on to your review of batch 2. And in the main, as you've put in the declaration, the large majority of that were rather unremarkable court judgments.
Could we get
they didn't bear any logo or
Excuse me,
marks.
Mr. Reese, could we get the paragraph number you're referring to?
21. I apologize, Your Honor.
Thank you.
Uh, 21 judgments not bearing any logo or marks typical of SITF or SPO documents, you said, and they have indeed been disclosed and exhibited. There were 6 pages, you have said in your review, that have not been disclosed and not exhibited, and they were documents in the Serbian language, you say, yes? See, batch 22 refers to Serbian documents.
Yes. Serbian language, yeah.
And at paragraph 23, you describe there being a copy of cover page of coordination request 61. And you say that document was replicated in the documents that you label batch 1 also. Is that right?
That is correct, yes.
You say that there is reference to an annex which was not present in the documents you label batch 2. Yes?
Excuse me, which paragraph?
Paragraph 23.
Yes, it says it's not included. Correct, sorry.
And the letter itself was not marked as confidential. That's right, isn't it?
That is correct, not expressly marked confidential.
No. So the document that's in batch 2 does not claim to be confidential. It refers to another document which was not in batch 2.
Correct.
And the document that you are describing in paragraph 23, that was a copy, not the original. I think that follows from your evidence yesterday when you said all documents were copies.
Correct.
And the document that you describe as in the corresponding batch 1 as the corresponding document, that also was a copy. Yes?
I apologize. Can you say again?
And the document that was in the batch, you label batch 1, that corresponds to the document you've described in 23, that was also a copy.
Correct.
And you cannot say whether the version in batch 2 was copied from the document in batch 1.
No, I cannot.
Or from the original,
No, I cannot.
or from another copy of the document that might be elsewhere.
No, I cannot. Yeah.
What checks, if any, have you carried out to check if the document you refer to in paragraph 23 is genuine?
I have checked the SPO database and I located this document.
You, just bear with me a second. So do you mean you located a corresponding copy in the database? Is that what you mean?
Let me say what I saw, Your Honor.
Please do.
Please do. Go ahead.
What I located in our database in Xylab or in DT is the document, the same document, uploaded electronically. That is what I saw. Uploaded in color, it appears color.
Right, so when you say the same document, do you mean the document that was in batch 2 had been scanned into the system and you saw that on the system?
No.
Right, so you don't mean you saw the same document on the system, you mean you saw a different document on the system, but one you thought corresponded to the document you describe in paragraph 23.
Maybe that's the better way of putting it.
And which system was that located in?
The majority, the vast majority, with the exception of only a few, coordination requests were uploaded into the Xylab system and they have received a registration number.
What about the document in 23? Which system was that in?
I'm sorry, I don't recall by heart.
You said nothing in the declaration about that document being located in the database, but you did in your annotated version that was disclosed the working day before you started your testimony. So that exercise was very recent, was it?
The exercise of checking whether it's in Xy, no. What was very recent is verbalizing it in a line or two so that I remember what I've done for the purpose of testifying here.
And are you saying that the document you saw in the system, whether it was, whichever system it was in, had an ERN number?
Because I do not remember these 6 pages where they were, but what I can say is when I wrote this declaration, I checked the 6 pages, whether we have them in our system, irrespective from the batch, and I can confirm that of the 6, 5 were in our system. Only the last one was not.
Okay, so we don't know which system. What you mean is somewhere you had a corresponding version of that document in the SPO's possession, yes?
I did not say somewhere. I'm saying that it is either registered in Xylab or it is found in a folder in DT.
Right. And, yeah, okay. And if registered, if in the folder in DT, presumably the document could be printed off?
Yes, it could.
Paragraph 24 then. You describe in paragraph 24 the document you label batch 2 is including a page of a SITF document relating to coordination request 61. That concerns logistical arrangements to carry out interviews, you say, and expressly refers to the confidentiality of the SITF investigations. The document itself does not claim to be confidential. Do you agree?
Do you mind if I look at the hard copy so I have the text, the complete text?
If you have it.
It's my annotated declaration.
The annotated declaration, you mean, yes.
I apologize.
Well, you can, by all means, look at it. And if there's further assistance in your annotated version you have there, please let us know.
There is no further assistance. It's just that in the annotated versions, I can look at the paragraphs completely. Here, I only see the second part or the first part of the paragraph.
I follow. Yeah, no, absolutely. So you want to see it on the one page, yes, paragraph 24.
Thank you. I have read the paragraph. Excuse me, what was your question?
The question was, although the document refers to the confidentiality of SITF investigations, the letter itself does not claim that it is confidential.
I can confirm, other than this sentence, which expressly refers to confidentiality, there is no additional marking to my recollection, but it would be included in the column indicia of confidentiality in the Annex to Declaration, May 2021.
So if the annex does not refer to the word confidential being attached to the letter itself, then we can infer that the letter doesn't claim to be confidential. Do you agree or not?
This document does not have an annex.
No, it doesn't.
It just is a two-page document.
Yes. And I'm asking you because you've seen it and I haven't.
I
Although it
apologize.
refers to the... Oh, I apologise. I thought you finished. Sorry, Ms. Bumper. Carry on.
I apologize. I didn't want to assume something. It is just that I have it in my head. Sorry.
Yep. So I follow that the document you describe in paragraph 24 doesn't have an annex. You say that it refers to the confidentiality of SITF investigations, and I'm asking you because you've seen the document and I haven't, to confirm that it follows that the letter did not itself claim to be confidential.
That is correct. It contains this reference to confidentiality. There was no other reference to confidentiality in this letter, other than the indicia which I have described. But it leaves it up to the court to decide how to judge these indicia.
Well, we can't leave it to the court to decide whether the letter claims to be confidential because the trial panel will not see it, only you do, which is why I'm asking you the question. But I think you've confirmed it. The letter did not claim itself to be confidential. Yes?
The letter did not have any other express confidential marking other than this sentence, and this exact sentence I have written in Annex 2 of that declaration, May 2021.
Paragraph 25 then. Sorry, before we do that, I ought to deal with some other matters under paragraph 24. Your answers may be the same as in relation to paragraph 23, but I should go through the process. The document you refer to in paragraph 24 that is from the documents you label batch 2 was a copy, yes?
Yes.
You refer to there being the same page included in batch 1. Do you mean that there was a corresponding version that was also a copy you saw in the document you label batch 1?
That is correct, yes.
And you cannot say whether the batch 2 copy was made from the batch 1 copy?
I cannot.
Or from an original, or indeed another copy elsewhere?
That is correct.
But you did, we know from your annotated declaration, locate a document that corresponded somewhere in the SPO database.
That is correct.
And again, are you unable to tell us which database?
I don't know it by heart, but I have records of it.
But it could, for example, have been in the DT folder and could be printed off.
If it's in the DT folder or in Xylab, it can be printed off.
Yeah, okay. Paragraph 25 then, please. This is a Serbian document. You describe. as having been issued by Serbian Deputy War Crimes Prosecutor. Yes?
Issued by 25.
Yes.
Mm-hmm.
Sorry. I'm my fault. Thank you for, you pointed out I'm wrong. Paragraph 25, coordination request 74. Yes?
It talks about coordination request 74.
It is, in fact, the cover page, not the request itself.
Your Honor, can I clarify something, please?
Yes, you may.
I would just like to make clear that when I talk about the request, that is the cover letter, and if there is an annex, it includes the annex. That's the request. But for the purpose of being precise, I then refer to the cover letter and the annex. But the whole document is our coordination request.
Okay, so although you refer in paragraph 25 to cover page and cover letter, there's no distinction there. They're the same document, are they?
Just one moment. Yes, that I refer to the same document.
Okay. And again, the letter itself does not claim to be confidential.
It refers to a confidential annex.
We can see that, but the question is, can you confirm that the cover letter itself does not claim to be confidential?
It is not mentioned in the paragraph. I believe you're correct, yeah.
Again, this document, not an original, it's a copy.
They're all copies.
And you cannot say whether the version in batch 2 that you say you saw was made from the version you report in the documents labelled batch 1, yes?
I cannot.
Or whether from the original or indeed any other copy.
I cannot.
But that document was in the SPO's, or sorry, to be accurate, a version of that document was in the SPO's possession, yes?
Correct.
Can you tell us this in relation to the documents you described in both paragraphs 23, 24 and 25? When those documents entered whichever SPO database they did?
Can I explain something more, please?
Yes.
When the coordination requests are drafted in Word, they are filed in a folder coordination requests. Then I found, so you have a Word version there. Then there are coordination requests which contain stamps, as you will see in the batches. So I have seen in Xylab, for instance, uploaded coordination requests which are registered, which contain a receipt stamp, which, for instance, in the Word version, which is in the corresponding DT folder, is not. So I just wanted to let you know.
Yeah, no, I follow. So in the DT folder, you'll see coordination request that is not stamped as being received.
Correct, a Word version.
But the SPO may also have copies of the SIT, the request that is stamped by the recipient as having received it.
Stamped by the recipient or not stamped. So sometimes I have both.
I see. I follow.
Okay.
But the specific question I asked was, can you say It may follow from your answer that you can't, but if you could directly answer the question, can you say when the documents that you've described in paragraphs 23, 24 and 25 entered the SPO databases?
I cannot recall.
And is there a way via the databases of ascertaining when a document was accessed?
I would refer to an IT person and assume yes, it is.
Did you check with IT for dates and times when these documents you were reviewing were last accessed within the SPO databases?
No, I did not, and this was not part of my assignment.
Do you know if anyone else was asked to do that task?
I have no information about that.
Paragraph 26. This is described as a Serbian document issued by the Serbian Deputy War Crimes Prosecutor. And it contains instructions to other Serbian authorities about the location of a person relating to, you say, coordination request 74. What steps have you taken to check if that's a genuine document?
For this document, I searched Xylab and I engaged the assistance of a Serbian interpreter to do the same.
Right? So what steps did you take to check that that was a genuine document? If any. If you haven't, it's fine.
I have.
Right.
Well, specifically, I would, like with all the documents, I would find words and find search criteria and search the system for text. And there's a certain mechanism how we do that, yes.
Okay. And is it a genuine document?
I have not located it in the database.
So does that mean it's a false document?
That means I don't know whether it is genuine or false.
And that's because, with the best will in the world, the SPO's recording systems will not record every document that they come into possession of?
I have not confirmed that we have possession of this document before it was leaked. I just said that I didn't find it in the database.
Yeah. Right. So you may have been in possession of it before or may not have been in possession of it before.
I could not locate it in the database. That would suggest to me that we don't have it if it is not a technical glitch and the system couldn't find the document. But I'm not an IT person.
No. And of course, it would require, one, there's the IT issue, you're not an IT person, but also, if a document is not submitted to the system by an individual, then it wouldn't be a surprise if you couldn't find it on the system.
That is correct.
Absolutely. So if an SPO officer receives a piece of paper and doesn't submit it to Xylab, then you won't find it on Xylab, will you?
Clearly not.
Clearly not. And likewise with the other systems, yes.
That is correct.
And there at paragraph 27, we have a similar document, again in Serbian.
Correct.
And this time you could find a version of it in the document you label batch 1.
That is correct.
And you could also find a version of this document in the SPO systems.
Yes, I could find it in the SPO database.
Again, tell us if you can't help us, but do you recall which database?
This document I would have found in Xylab because it has not been offered by us, so it cannot be in DT.
And
as a Word version, sorry to be precise.
And all of the versions you saw effectively copies?
That is correct.
I'll be accurate. What I mean by that is the version that you saw in the documents you label batch 1 and the version you label as documents batch 2, yes?
I only saw copies.
And you can't say whether the version in batch 2 is a copy of the version in batch 1 or the original or some other copy?
No, I cannot.
Thank you. That's a convenient point to break.
You may escort the witness out of the courtroom. We'll take a half-hour break, Ms. Pumper. So please be available and back at 11:30, and we are adjourned until that time.
All rise. All rise.
Please be seated. Everyone ready to proceed? Madam Usher, you may call in bring in the witness. You can be seated, Ms. Pumper.
Thank you.
Mr. Rees, you have the floor.
Thank you, Your Honour. So we are now at paragraph 28 of your declaration. And you begin this part of the declaration by explaining that you conducted a review of documents that you understood were seized at the KLA-WVA on the 22nd of September 2020 and labelled by you as batch 3, yes?
That is correct.
And you can confirm that you were not present at the KLA-WVA on the 22nd of September 2020?
That is correct.
You were directed in direct examination to document SPOE 00220-194 and 195. If you can look at those briefly, please.
Do we have an MFI for that? I'm sorry, I'll repeat that. Do we have an MFI for that, Madam Court Officer?
Your Honours, I'm having trouble locating the ERN number. Perhaps counsel could repeat.
Okay, go ahead then.
SPOE 00220-914.
Your Honours, that's admitted Exhibit P54.
I'm grateful. Thank you, Madam Court Officer. Can we fit to height on this document, please? Thank you. We can see here, this is one of those, it's obviously a hard copy document, but not with a ERN number manually stamped, but with the red lettering SPOE 00220-914 applied to the bottom, yes?
Correct.
And we can see at the top, typed is The Hague 9 September 2020, although the 9 is crossed out, replaced by manuscript hand with the numerals 22, and then there's a handwritten entry, the date changed by, and then an SPO officer who, in court we can all see obviously who it is, and you've mentioned before, yes?
Correct.
Then the document is described as an order. It's addressed to Mr. Gucati and or the KLA War Veterans Association. It provides, you are hereby ordered to, 1, immediately produce all documents and records, including internal work product of the Specialist Prosecutor's Office, and 2, refrain from recording or copying in whatever form and further disseminating by whatever means of communication the documents or their content. And at the bottom there is a facsimile of the signature of the Specialist Prosecutor. Yes?
Correct?
And it does not, on the face of it, record whether any documents or records were seized as a result of the order, or if they were what documents and records. Do you agree?
It states to produce all documents and records, including internal work product of the Specialist Prosecutor's Office. That's what I read.
Yes, thank you. But can you confirm it does not record whether any documents and records were seized or produced as a result of this order, and if so, what?
No, that's the order.
Indeed. The other document was SPOE 00220915, red. This is...
This has a P number.
Your Honor, it's B58 for the record.
Thank you, I'm grateful. This is a acknowledgement of delivery form, again, a hard copy document. Doesn't have the manual ERN document number stamped on it. It does have in red and what looks like an electronic entry right at the bottom of the page. SPOE 00220915, and it is described as an acknowledgement of delivery. The recipient's name is written in manuscript. There is a signature, date, time. There is a box ticked for recipient signed for service. The name of an SPO officer, same SPO officer that we've seen on the last form and indeed you referred to previously. The date and time, and the form, the purpose of the form is clear. In the second line, the recipient is asked to sign to acknowledge receipt of the order to produce documents and records, yes?
Correct.
And there's nothing on this form either that confirms that as a result of the order, any documents and records were produced.
That is correct.
Or if so, what?
Correct.
And on the two documents, the order and the acknowledgement of delivery of the order, nothing to say that if any documents and records were produced as a result of the order, and if they were placed in evidence bags, what evidence bag they were placed in.
That is correct.
Going back then to your declaration at paragraph 28, please. So you were asked to review documents that you were told had been seized at the KLAWVA, and you labelled them batch 3, and at paragraph 29, you described batch 3 as composing of 2 incomplete documents counting 244 and 245 pages, respectively, of the same document. In particular, you said batch 3 includes complete copies of an SPO confidential document counting 261 pages, which pertains to SPO investigations and official proceedings, and which constitutes internal work product. Just pause in there. Did you mean to say that it was a confidential document, or did you mean something else?
I'm not sure what you mean.
Well, did you mean to assert that it was confidential, or were you simply describing it as a document? Well, what did you mean?
I wrote that it is a confidential document because it had confidential indicia on it.
So, your opinion was it was a confidential document because you saw indicia of confidentiality on it.
It had indicia on the document, and that's why I referred to it as a confidential document. Expressly referred as confidential, that's why I mentioned a confidential document.
You went on to say that, well, do you know who classified it as confidential?
No, I don't.
Do you know whether they had authority to classify it as confidential?
No, I don't.
You went on to say batch 3 is written in the English language and includes an analysis of available evidence and applicable law in relation to 5 SPO suspects. And then you named them. Can we, at this stage, go into private session? Again, I am of the view that the material which I'm about to ask about is not, it does not require protection, but I understand the trial panel's ruling, and I'm doing my best to abide by it, so can I invite the court to go into private session at this stage?
Concerning names?
Well, it depends on the answers from the witness. If the witness, when I ask questions, replies don't know, then there will be no names. But
No,
if she,
I know, but the thing you're worried about complying with our order.
I am.
Excuse me. The thing you're worried about is names being used that we've forbidden. And you don't agree with that, but I understand that.
Yes.
Okay. We will go into private session.
Obviously, if I've misunderstood the scope
No,
of the
no.
ruling, then I invite Your Honour to tell us we can go back into public proceedings as soon as we can.
No, I'm merely trying to get on the record the reason for going into private
I
session.
understand.
Your Honours, we're now in private session.
Thank you. You can proceed, Mr. Rees.
Who authored the document that you describe as confidential document, analysis of available evidence and applicable law?
Objection, Your Honor. It goes to information subject to pending non-disclosure requests.
Sustained.
Do you know which current or former SPO staff member contributed to its creation?
I don't know that.
Do you know who authored the document?
I don't know that.
Do you know which current or former SPO staff member had access to that document electronically?
This is also objection, Your Honor, is also information subject to pending non-disclosure requests.
Your objection is overruled. You may answer the question.
Would you repeat the question, please?
Do you know which current or former SPO staff member had access to that document electronically?
Please give me a moment. I have to think about this answer.
Take your time.
Your Honor, can I comment something, please? Ask something?
You want to ask the court or
The court.
Yes, go ahead.
When the defense, when you say whether I know, I just want to say that I have not looked into these matters, and that for me I would make assumptions, like from a system, what could be.
You're not to make assumptions. The question was very direct. Do you know?
I do not know.
In accordance with normal operating procedures, as you would understand them, who would you expect to have access to that document electronically?
Objection, Your Honor, is hypothetical and argumentative.
If you know, you may answer that.
I don't know.
So,
I don't know because I don't know where it was placed.
you had access to that document electronically via the DT folder?
I did not have access to that document. I was not in the office.
But did you not find a version of it as part of your review in the DT folder?
When I conducted the research, I found a version on DT.
So you had access to it?
When I conducted the research, I had access to it.
Does that mean that you were specifically given access to it for the purpose of the review?
No, that means that I don't know where the document was before I have conducted the review. I found it when I conducted the review.
albeit we had no notice that he was going to do that. Perhaps the witness should retire for a moment so I can raise this with the trial panel in her absence.
If you're just talking about whether we will be in private or public session, we'll stay in private session for the time being.
Well, I think I'll raise it, not only to do the issue as to whether it's public or private, but also I want to raise with the trial panel what I'm about to ask about. Okay? Because I certainly don't want to do anything that
No,
the
I
trial
understand.
panel thinks I shouldn't have done.
Ms. Usher, would you please escort the witness out of Go ahead, Mr. Rees.
In the opening of the case, the specialist prosecutor, with no notice to us, and in public session, asserted that the documents were stolen. And we have had no evidence disclosed to us to that effect. We had no material provided to us under Rule 102.1, suggesting that the prosecution were intending to adduce any evidence to that effect. And indeed, when we asked in the days leading to the opening whether, for example, a draft opening statement might be provided to us, acknowledging that it would, of course, be without prejudice and could be amended at any stage, but so we could see whether there was anything we might object to, the SPO said there was nothing in the rules that required them to do so, and they would not, which, of course, was it within their rights, because there isn't anything in the opening, in the rules that require that process. But it did mean that we were taken wholly by surprise when the specialist prosecutor asserted that. And there has been no indication since that, despite, as part of the opening of the case, intended to be a summary of the issues and the evidence that the prosecution would call to prove matters, we've had no indication since that the SPO intends to call any evidence on that point. In those circumstances, I had intended to explore with this witness whether she knows anything about that, whether we are going to receive any information that points to that effect publicly during the course of this trial, and to explore that further with her. You will understand that I can't do that with anyone else other than her or potentially the second SPO officer, Mira Djukic. And it may well be that in relation to these questions, she answers as she has done thus far. I don't know. And it may well be, more likely perhaps, that the second SPO officer they intend to call, who is only involved in witness security, we're told, may well say, I don't know. But if that's right, it does seem to us that the prosecution can't open a matter, make an assertion in opening, and not expect us to explore the basis for that assertion, nor indeed can they expect to make an assertion like that in public and leave it hanging in the air without any evidence addressing it at all. If it's addressed in evidence, and the answer from this witness and the security officer is, I know nothing about that, then at least the public will have seen that it was an assertion made without any foundation in evidence.
Yes, Your Honor. First of all, as clarified also by the presiding judge at the start of the opening statements are not the presentation of the evidence of the case. Second, we were not provided with a specific reference to the information the defense is referring to. And third, in the course of the opening statement, the specialist prosecutors also made very clear that the case is not about how the documents reached the KLA World Veteran Association, but how they were subsequently disseminated and distributed. Finally, this witness already explained that she had made no investigations on this matter, so this is not the witness who is able to answer any questions in this respect.
We'll allow you to go on with this witness, but as you phrased your question, you said you were intending to ask her about basically about the plans of the prosecution in this case. She's not the prosecutor. You can certainly ask her a direct question about what she knows about the investigation. You said you wanted to ask her if she knew of any information that was going to be presented. She's not in charge of evidence being presented.
No, and I did say that. I didn't mean that would be put to the witness as a question. I do follow. I can run through the questions
just direct questions to her are okay. Give us a time. Give the prosecution an opportunity to object. I'll give the witness the same opportunity. Madam Prosecutor, Mr. Smith raised this issue during opening statements, and I think they can at least address them.
I just identified the right quote, if it's of interest for the record. I found the quote which says, "The accused are charged with illegally disseminating these documents, not with actually stealing them." And to be very clear, we are actually investigating, et cetera, the theft of the documents in question.
You're absolutely correct. You're absolutely correct, and the panel is aware of that, but we are in the process of a trial with reasonable questions being asked.
Yeah.
Under the circumstances, but you understand my direction.
I absolutely do, and I will not ask her anything about the intentions of the prosecution.
All right. Madam Usher, would you please bring the witness back in?
Is this to be in private or open session?
We are still in private session.
Thank you.
We only have a few minutes left. Mr. Reese is going to ask you a few more questions, but please pause before you answer, which you're very good at doing, and to allow the prosecution, if they wish, to interpose an objection. Do you understand?
Yes, I do.
All right. Go ahead, Mr. Reese.
You have said that you know nothing about the investigation into the process by which the documents arrived at the KLA War Veterans Association headquarters. If I was to ask you then if you were aware of any evidence that the Specialist Prosecutor's Office has that documents were stolen, what would you say?
I have no idea.
So, right.
I have some. I just have a.
Can you confirm that in the period between 22nd of September and December 2020, that there were some 25 staff members including 4 team leaders whose time at the SPO came to an end?
No, I cannot confirm that.
You get the numbers. Can you confirm that there was, well, are you aware of any staff members whose time at the SPO came to an end during that period?
Your Honor, objection to this question as to the relevance of it.
You're going to have to state your case a bit with this witness. The relevance of this is quite unknown at this point.
We said it as part of the circumstantial picture which points towards the involvement of the SPO in the form of individuals who had a connection with the SPO being involved in that process. The fact, if she confirms it, that there were staff members that lost their position with the SPO is part of that circumstantial picture the court can consider. If she can't confirm that, she can't confirm that.
She's answered that once. You can ask her one more question on that line. If it's not fruitful, we'll stop that.
Well, yeah, the last question she hasn't answered. Are you aware of any staff members whose time at the SPO came to an end during that period, which was period between the 22nd of September and December 2020?
I don't recall whether anyone specifically left at that time.
Now, obviously, there's 10 minutes to go. We have more questions for the witnesses we flagged yesterday, but it doesn't seem to me fruitful for me to start a topic now. Can I ask that we break at this stage and resume on Monday, I think it is.
Can you give us a hint as to how much longer you will be with this witness? I don't want a couple of Welsh minutes is not going to work.
No, and it won't be a couple of Welsh minutes. I will be finished on Monday.
All day Monday?
As the trial panel knows, and acknowledged yesterday, there is, of course, the hearing this afternoon, which may have an impact on matters. There are also other matters that are outstanding, including, for example, the decision of the SPO as to what they do about the official notes from 2 witnesses who were involved on the days of the searches. That's still to be determined, and I have had some constructive discussion with my colleagues across the way about that, and I hope that the more clarity is brought to it, the shorter I can be in due course. But
I'm just worrying about Mr. Cadman and whether or not he's going to get a chance to ask some questions.
I can say, Your Honour, you need not worry about me. There is a fair amount of consultation going on between the defence teams.
All right, you can escort the witness out. We will adjourn for the day.
If I may, just for scheduling purposes, ask one question. Yes. In relation to the oral order of the 8th of September 2021 from the trial panel, which ordered the SPO to call W04866 as the last of the 3 SPO witnesses, the SPO, together with the registry support, had made plans for this witness to attend the court next week, at the end of next week. I believe that it will not be possible to cover all of the 3 SPO witnesses within the framework of next week. So we ask, based on the time required for cross-examination of the first witness, so we would ask the court, in case that is not possible, if we could invert the order of the witnesses and have W04866 examined before W04842.
Thank you. Just one moment. First of all, let's go back into public session.
Your Honors, we're back in public session.
Does the defense wish to respond to the question from the prosecutor?
Only to say that the question was asked of us what our view was by the prosecutor. We took the view that there's a degree of uncertainty about the progress of next week, particularly in light of the hearing this afternoon. And the scope of the prosecution case, they still have to answer the matter that they've been ordered to answer by the end of Monday. So we felt that we couldn't give much assistance on it. It is, of course, a matter for the trial panel, ultimately, and indeed the SPO for when they call their witnesses, and to do that as efficiently as possible.
You're not making an objection to it at this time. Mr. Cadman?
I've communicated the same position to the SPO before Your Honours came in this morning.
Because of the fact that there's no objection, and that witness is apparently coming from somewhere else, and travel is always an issue, especially during the last year or so, we will grant the request, and so the order will be after Ms. Pumper. That witness will then testify, followed by Mr. Jukic. Okay. All right. So we will be in adjournment and see you Monday at 9:30.
All rise.